Before going into the Negotiable Instrument Act in detail, first of all, we need to understand what we mean by negotiating or negotiable, and what are the negotiable instruments. Negotiable instruments are those instruments which can be negotiated. For examples like bills of exchange, hundi, checks, and bills of exchange, check, and promissory note. Very importantly, promissory note. So, what is the definition of negotiable instruments? The word negotiable means transferable by delivery. By the word instrument means a written document created in favor of someone, some person. That is called a negotiable. That is called a negotiation of an instrument. It literally means a written document which creates a right in favor of somebody and is freely transferable by delivery. A negotiable instrument is a piece of paper which a person to a certain sum of money and which is transferable from one to another person by a delivery or by endorsement and delivery. So that is a negotiable instrument. So basically negotiable instruments are of three types. The first and foremost, mainly which is used in a very high prevalent conditions, are checks. Checks, bank checks. Then second is bill of exchange. And third is promissory note. And many other local negotiable instruments are also there. From one of those is hundi. But hundi is not covered under this act, NI Act. So we are coming to the this law defines these instruments and also deals with each type of them individually. It governs the use of checks, promissory notes, and bills of exchange. There are customary payment methods also similar to these negotiable instruments like hundis, but this law does not cover them. Negotiable instruments are basically three types: promissory note, bills of exchange, and check. Now, what is a bill of exchange? A bill of exchange is an instrument in writing containing an unconditional order signed by the maker, directing a certain person to pay a certain sum of money only to or to order of certain person or the bearer of the instrument. That is called a bill of exchange. And in every negotiable instrument, there are connected parties from which this transaction flows. For example, the transaction starts from the drawer, then it goes to drawee, and then comes the third party in the picture is a payee. Now, what is a drawer? The drawer is that person who makes public orders to pay a bill of exchange. Drawee, the person who is directed to pay on bill. On acceptance, he becomes acceptor. And the payee is the person to whom the payment is to be made. Drawer and payee can be the same person. For this purpose, I would like to give one example. For example, X sells goods worth rupees 2000 to Y and allow him 3 months time to pay the price. X then draws a bill on Y 3 months after the date. Pay to my order the sum of rupees 2000 for value received. So X is drawer and Y is drawee. So negotiable instruments are bills of exchange, promissory note, and mainly and most importantly, checks. And instruments are also categorized in non-negotiable instruments. For example, such kinds of instruments are money orders, postal orders, share certificates. So these documents are non-negotiable. To pay a certain sum of money to a specified person, as per the Negotiable Instrument Act, check is a bill of exchange drawn on a specified banker and not expressed to payable otherwise than on demand. Now, check related terms are as same as of bills of exchange and promissory note. Among this, drawer is there, drawee is there, and pay is there. Now, during the course, there is a term which is called a holder of an instrument. What is a holder of an instrument? Holder, due to easy transferability of the value of instrument, it provides a legal protection to different mercantile instruments. It presents orderly and authoritative statement of a leading rules of law relating to the negotiable instrument. So holder is that person who's having a check in hand and he present that check in the bank for encashment. It can be directly to his account, or if it is a cross pay or it is a account pay, then the amount will go to the account, his account, holder's account. If it's a bearer check, he can encash it. And coming back to the scope and objective of the NI Act, why it is being made and brought. So this act focus and concentrates on financial transactions which are for business purposes in the society and to regulate it and to secure the ends of financial transaction between two parties. So that is why the NI Act has been brought. And the NI Act, the main object is to penalize, to bring the penalty to the defaulting party who issues the check and later on he fails to honor it. As far as the whole NI Act is concerned, it is a very exhaustive act and a very broad act, but the most important section is the penal section is 138 of NI Act, which says that where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for that discharge in whole or in part for any debt or other liability is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account. The payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of the information by him from the bank regarding the return of the check as unpaid, and the drawer of the check fails to make the payment of the said amount of money. So section 138 clear cut provides the safety and security to the payee or holder in due course to bring the law into the motion, and as soon as the check gets bounced, he has to send the legal notice to the drawer through with the help of competent advocate, or he can send by himself also. Section 138 says clearly that after the bouncing of the check, the payee has to send the notice to the drawer of the check for meeting his legally enforceable liability. which is standing against the payment and to be given to the payee. So as soon as the check gets bounced, the memo is raised by the bank. After receiving the information from the bank of that memo, within 15 days, notice, this is a very technical section, within 30 days. Notice period for giving a notice is 30 days of the receipt of the information by him from the bank regarding the return of the check as unpaid. Then the drawer of the such check fails to make the payment of the said amount of the money to pay, or as the case may be, to the holder in due course of the check within 15 days of the receipt of the said notice, then the cause of action arises from the 16th day, and within 30 days complaint has to be filed in the court of law. Now, one of the most important point in the cases relating to the check bouncing is that notice is very much essential. After check is bounced, notice is very much essential, and it needs to be sent through a proper channel like post office or recognized courier services to the defaulter. And the most essential ingredient is that it has to be received by the drawer. If it is not received, then the very scheme of this check bouncing case and the Negotiable Instrument Acts becomes null. Then in that case, if he is not traceable, the drawer of the check is not traceable, or he is absconding, then police case comes in the picture. So this is very essential point which we have to note. Now, as far as if the notice is being received by the drawer and he may reply, he may not reply to the notice, then after receipt of the notice, within 30 days, a complainant who is a payee, a complainant is entitled to lodge a complaint in the court of law. After the complaint is lodged, then case takes in due course the case takes place, and two sections in the ANA Act which are very essential and very important, which gives the presumption in the favor of the holder of the check. One of the most important section is 118, Special Rules of Evidence, Chapter 8, Section 118, which says that presumptions as to the Negotiable Instruments Act, until the contrary is proved, the following presumptions shall be made of consideration. Point number A is of consideration, that every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated or transferred, was accepted, endorsed, negotiated or transferred for consideration. So consideration is very much important. Then as to date, that every negotiable instrument bearing a date was made or drawn on such date. Then as to the time of the acceptance, that every accepted bill of exchange was accepted within reasonable time after its dates and before its maturity. Then transfer, that every transfer of negotiable instrument was made before its maturity. As to the order of endorsements, that endorsements appearing upon a negotiable instrument were made in the order in which they appear thereupon. And that lost promissory note, bill of exchange or check was duly stamped. And the most important point is that the holder is a holder in due course, that the holder of the negotiable instrument is a holder in due course, provided that where the instrument has been obtained from its lawful owner or from any person in lawful custody thereof by means of an offense or fraud, or has been obtained from the maker of or acceptor thereof thereby means of an offense or fraud or for unlawful consideration, the burden of proving that the holder is a holder in due course lies upon him. And the another section is section 139, which gives clear-cut presumption in the favor of the complainant, which says as it is follows: presumption in favor of holder. It shall be presumed unless the contrary is proved that the holder of check received the check of the nature referred to in section 138, which is defined in the penal provision of section 138. It is for the discharge in whole or in part of any debt or other liability. The very important aspect and essential point is that there should be something in black and white in the transaction between A and B. If the transaction gets failed and if another party wants to raise allegation or lodge a complaint against the other, apart from the check, there should be something in evidentiary point of view, like in black and white documents or oral evidence. Oral evidence. Merely having a check will not suffice to achieve the object of this particular act. So it clearly emphasizes and tells that legally enforceable debt. Debt has to be legally enforceable debt. Now there are under section 140, which says that defense which may not be allowed in any prosecution under section 138. It shall not be a defense in a prosecution for an offense under section 138 that the drawer had no reason to believe when he issued the check that the check may be dishonored on the presentment for the reason stated in that section. So after issuing a check, he cannot come back. Once the check is issued, it is a legal tender. Now, the transaction can be between two individuals as well as individual and the company and the company and the individual. So all these aspects covered from section 138 to section 143 to 144. Section 141, which clearly states about the offenses by the companies. If the person committing an offense under section 138 is a company, every person who at the time of offense was committed was in charge of and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly, provided that nothing contained in this subsection shall render any person liable to punishment if he proves that the offense was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offense. Then second proviso says, notwithstanding anything contained in subsection 1 where any offense under this act has been committed by a company and it is proved that the offense has been committed with the consent or connivance of or is attributable to any neglect on the part of any director, manager, secretary or other officers of the company, such director, manager, secretary or other officers shall also be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. In my personal experience, I have come through one case in which the father was the account holder. He issued the check to the another party, and father was the account holder of that particular account from which the check was issued, and he authorized her daughter to become an authorized signatory for that particular account. And during at that time transaction took place, the check was raised and issued, and it was signed by only her daughter. So in the case, both father and daughter became the accused. So someone has to be very careful at the time of doing anything for the sake of making the ends. So unnecessarily both
also, I would like to interrupt. Now, this case that
Yes,
you've
madam.
discussed, if we do the opposite, like if the receiver takes the check from the drawer in the name of his daughter and not in his name, though the contract is in his name. So, and it is dishonored. So the daughter, can she go to the court for dishonor or for under this act? Because the check is not given to the father, it is given to the daughter. It's given in the name of the daughter, though the contract is between the father and the drawer.
Correct, correct, correct. Yeah. Yes, she can approach. She can approach. She can send a notice, and she can submit all the facts in the notice.
But it is only says that the receiver or the party can go to the court. She is
Yes,
not a
party can
party.
go to, though she may not be a party, but at the time of giving a check or accepting a check, there might be something in written consideration between them at that time. We can presume that at the time of accepting the mode of payment, so this aspect has to be covered
Okay,
because
and
it is a
suppose there is
subsequent
nothing in
because it is
writing.
a subsequent development. Then if
Suppose
there
there
is a
is
nothing, hmm, if there is nothing in writing, the tender of the check itself gives the court to take a inference. Adverse inference can be drawn by the court against the drawer of the check.
okay, okay, thanks.
So under section 142, cognizance of offences. No court shall take cognizance of any offence punishable under section 138 except upon a complaint in writing made by the payee or as the case may be, the holder in due course of the check. Such complaint is made within 1 month of the date on which the cause of action arises under clause C of the proviso to the section 138. Now, what is cause of action? Cause of action is very much important. We can say when I was in the practice, 50% people fail to understand what is the cause of action and when it arises in the cases of section 138, check bouncing cases. When the notice is sent, when the notice is received, from the date of the receipt of the notice, that 16th day, the cause of action arises, and that 30 days are given. And one of the most important aspect is that there after sending of the notice and after the receipt of the notice by the drawer, 15 days are compulsory, which they have to wait. They cannot bypass that statutory period. The complainant or the prosecution cannot bypass that 15 days periods. Many cases are there in which 15 days were not passed, and prior to that only they have taken the cognizance and filed the complaint in the court of law. All those complaints, though the process were issued under those complaints, but all those cases ultimately failed in the upper courts, like for example High Court and Supreme Court. Such kinds of cases went up to Supreme Court, and Supreme Court clearly stated in that judgment that as per the scheme of the law has to be proceeded because the fair opportunity was not given to the accused, to consider the claim, whether he wished to give a reply or whether he wants to settle it. So this is a very technical act and very technical aspects are involved, which has to be taken care and look into very carefully. So coming back to the section 142, Proviso B. Such complaint is made within 1 month of the date on which the cause of action arises under clause C of the Proviso 138. And under bracket it says, provided that the cognizance of the complainant may be taken by the court after the prescribed period if the complainant satisfied the court that he had sufficient cause for not making a complaint within such period. If there is a delay, even if it is of for a 1 day in lodging a complaint in the court of law, earlier there was not there this provision, and if delay used to take place, the court used to refuse it or deny it, the process of the complaint. Then this amendment came 61 inserted by Act 55 of 2002, with effect from 6 to 2003, then the delay came to be condoned, came to be condoned in the course of actions and in cases. If there is a delay, then one has to explain the delay in lodging and complaint while making a separate application along with the separate affidavit in support of that application in the court of law, and the notice are being issued by the court on the other side to give their reply. If the court is satisfied, then only the process are issued. Now the another aspect in these cases under section 143 of the NI Act, power of the court is to deal with these cases are in very summarily in nature. Summarily in nature. All offences under this chapter shall be tried by a judicial magistrate of the first class or by a metropolitan magistrate, and the provisions of section 262 to 265 of the CRPC shall come in the picture to conduct the trial, provided that in the case of any conviction in a summary trial under this section, it shall be lawful for the magistrate to pass sentence of imprisonment for a term not exceeding 1 year, and now the punishment is there for up to 2 years, and the amount of fine is also there, and double of the check amount can also be granted. And as far as possible, the cases under this act, as far as possible, practically has to be summed up by the trial courts within 6 months. Within 6 months. But usually it does not take place, and it goes up to years for a year, depending upon the cases and depending upon the list of the accused. If the cases between the individual and the company, and if the cases are between the companies and companies, then it takes very long for first of all for the issuing process, then after that to serve them with the summons. It becomes very long exercise. So this under this act, one more very essential section is there, which is very helpful for the complainant. That is section 145, which gives a power or gives a provision to the complainant to give his evidence in the form of affidavit in the court of law. What the section says, let's read. The evidence of the complainant may be given by him on affidavit and may, subject to all just exceptions, be read in evidence in any inquiry, trial, or other proceedings under the said code. Proviso 2 of section 145 says the court may, if it thinks fit, and shall, on the application of the prosecution or the accused, summon and examine any person giving evidence on affidavit as to the facts contained therein. So it is for the choice of the complainant, apart from his evidence as a complainant in the case, if he wants to bring any other witness in the support of his case, he may file his affidavit, or directly he may bring him into the witness box and can lead the chief, examination in chief. So both the options are open for the complainant. And very important factor and aspect in these cases, that these cases are always compoundable.
Abhishek, wonderful presentation.
Yes, sir, Abhishek, sir, please, sir. Very
We are
informative,
very proud of
actually.
you.
Very informative, sir.
The offenses under the NI Act are very much compoundable. That means can be settled right from the inception till deception, right from the sending notice till the judgment. Case can be settled and can be compounded between the parties. So with this information and this section, I sum up my lecture. If there are questions, anybody are free to ask me a question.
अभिषेक, मेरा एक प्रश्न है.
Yes, sir.
मेरा क्वेश्चन ये है कि एक कंपनी है और कंपनी एक पर्सन माना जाता है, ठीक है? उसमें कई डायरेक्टर होते हैं और एक डायरेक्टर अपना रेजिग्नेशन दे जाता है वो ऑथराइज सिग्नेटरी होता है और
Correct.
उसका रेजिग्नेशन कंपनी उठा के रजिस्ट्रार ऑफ कंपनीज को भेज देती है, वहां उसका रेजिग्नेशन स्वीकार हो जाता है और उसका नाम काट दिया जाता है। उसके रेजिग्नेशन देने के 1 साल बाद मेच्योरिटी डेट आती है, फिर वो चेक बाउंस हो जाता है। तो क्या जो रिजाइन कर गया डायरेक्टर वो लायबिल है?
He is not liable.
नॉट लायबिल ना?
Yes, he is not liable. He is not liable as at the time of the presentation of the check. At the time of the presentation of the check, he was not dealing with the day-to-day affairs of the company, and he resigned, and he was not an active member at that time.
हाँ, second, legal liability. Can you explain legal liability?
Legally enforceable liability.
हाँ, किस
Legally-
लीगल लाइबिलिटी को उसको प्रूव करना होता है कंप्लेनेंट को?
Correct. Correct. It is very much essential and very much required to bring the goal into the goal post, and he has to prove his case and prove his liability, which is legally enforceable liability. Only by having a check and depositing in the bank does not give him succession and succeed in his case. Recently, one Supreme Court judgment has come. In that judgment, the Supreme Court has come up with the idea to bring all the cases arising out of the one transaction within 1 year, to be clubbed and to be clubbed into one case arising from the single transaction.
We thank Abhishek sir. Thank you so much for taking a class. Everyone who's present in the panel.
If there is a time, I would like to clarify one more thing.
Yes, sir.
If there is a time, if that time is remained, I would like to clarify one more thing. Many people thinks and have an opinion that as the checks are controlled as per the NI Act and the penalizing provision is there only for check and not covered for promissory note and bills of exchange. So in this, for this contention, my submission is that though the bills of exchange is there, though the promissory note is there, and are being used and are made during the transaction between the two parties, but the mode of the payment are always the checks. This point has to be taken into consideration, that the mode of the payment which is decided between the parties are always a check. That's why the legislation has aimed and covered on the basis of check.
Definitely, sir. Definitely. Thank you so much for your valuable insights. And I thank everyone who is present on the panel today. All the seniors, sir, thank you so much for being here, for also, going through whatever presentations we give. We make our mistakes also. We do something decent also, I think. And all the people who are here who are making this possible. Also, I want to share that we want to make this as a platform for all advocates who want to come up and convey their thoughts. So, with that respect, also, if there are other people also who want to, conduct a session, then please go ahead, email us. Details are in the chat box. info@vestralex.com. At any point of time, you can come back to us. Along with that, I want to thank everyone. And Abhishek sir, thank you so much for being the faculty today. We'll be here with you for the next sessions, the next classes.